have something you wanted to put on the record?
This morning, as we were preparing for the court, I noticed that Mr. Samuels was preparing a PowerPoint. And although I have no objection to their work product being presented, I do have an objection to new materials that are being presented. I interviewed this individual, and prior to that interview, he provided a report based on his findings of the clinical interview with the defendant, as well as the testing interview that he conducted with the defendant. And at that time, we discussed all of his notes and all of his findings. Today, it's a new story. All of these slides, every one of these, are new to the state. There's an issue with disclosure here under Rule 15. I'm sure this is not something that was done overnight, and I'm sure this is something that could have been provided in advance of this. But I will specifically designate the slides for the court and my objection to it. Specifically, one of the things that he talks about, or the first slide, is a cross-section of the brain. Mr. Samuels is a psychologist, not a psychiatrist or a medical doctor. He never indicated to me that he had any training in any sort of issues related to the brain. Now he's bringing a cross-section of the brain. I don't know exactly what he's going to say as it applies to the defendant, and that's the problem. The second slide involves a Time magazine article, and it's titled, "Your Brain Under Fire." I don't know how that is relevant, what somebody in Time magazine thinks about your brain under fire, but it's also hearsay, and I do believe it would be unreliable. I did not read the article. The constraints of time did not allow me to even assimilate exactly what it was saying. Number 3 is a slide from a quote from Time magazine from an article dated January 28, 2013, in which it says something like, "Your brain under fire." Again, I don't see the relevance to this case, what somebody in Time magazine may have written. And if they were going to use it, certainly they should have disclosed it. Number 4, and there's a slide about PTSD, something like that, mentally something or other, and it's written by a PhD. I didn't even have time to write down the whole section of it, but it's, again, new material that was available before. Somehow they've chosen to hide it and present it in a somewhat surprised manner today. Number 5 is a slide involving something called intrusive memories. It's an article. And again, this was not disclosed. I don't know exactly what it says because I didn't get a chance to meaningfully read it. Number 6, it talks about correlation or something like that, a victim-offender relationship. And then he starts talking about 2 types of homicide, instrumental and expressive. These were never mentioned by this individual when we conducted the interview. What he did indicate as part of his report was that he believed that this was not a premeditated act and that it was in self-defense. Of course, the court has already ruled that he cannot express those views, and now he's talking about something called instrumental and expressive homicide, something that's totally new, something that's new to the table here, and clearly it's just unfair to expect the state to just look at that and somehow be able to respond to that. Number 7, 8 and 9, and maybe 10, all talk about this instrumental and reactive homicide, or these 2 types of homicide. Obviously, he feels that he needs to define them for the jury. I don't know what the definition of instrumental or reactive is, but number 7 is a definition of both instrumental and reactive. Number 8 talks about purely reactive homicide. Number 9 is purely instrumental homicide. And number 10 talks about instrumental and expressive homicide as it applies to Finland, or a Finnish study that was conducted. Again, none of this has been disclosed to the state. The next slide that he has indicates its violence and personality disorders. And I don't know who authored that. I was writing quickly, but again, if he was going to hang his hat on this, he should have told us about it. The report is clear that this doctor opines that what the defendant had And his opinion is that the defendant suffered from post-traumatic stress disorder at the time of this killing. And it involved a certain stressor that triggered this post-traumatic stress disorder. Now we're talking about totally different things, and it appears that this opinion has been tailored to maybe perhaps conversations that this individual may have had with the defendant recently. And the reason that I say that is that his report was completed back on June 21 of 2010, and I do know that as recently as of December of last year, he was still visiting the defendant. So it appears that maybe, I don't even know what he was thinking at that point. So number 13, it talks about amnesia and crime and dissociative amnesia, something he didn't talk to me about. 14 is transient amnesic syndromes, again, nothing that he discussed with me. And then 15 is transient global amnesia, and these all have the text of this particular idea that he wants to express. So it's not that it hasn't been in written form. It's not that they couldn't have turned this over to me. It's just that they waited till the morning of court. And number 16, which is the last one I believe, talks about the stressed hippocampus, something about synaptic plasticity and cost memories, something like that. I object to all of those. He has a report. I interviewed him with regard to that report. Now he comes in with something totally new and different. Not only does he come in with something new and different, but he comes in it in PowerPoint form. And the reason that's particularly egregious because that took some time to put together, and that's been available for some time. If we were to look at the other side of the coin, and, for example, my expert, Janine DeMarte, were to come in here with a PowerPoint in which she had totally changed what she had talked about, and at that point, I guess I could say we can only imagine what would happen if I were to say to the court, well, they can just look at it minutes before this and, take a look at it and see if there's anything new there, let's just go forward. My view with regard to this presentation is that he has changed it. We arrive here after having interviewed him, and that's the purpose of the interview, so that we know what he's going to say. If he's going to change something, there is a duty to tell us about it, and I think that they have forsaken that duty. There's a violation of Rule 15, and I have no problem with him testifying, but I do have a problem to this PowerPoint and any new opinions that he may come up with. So I would object to that.
Ms. Wilmot.
Well, Judge, when the state says he has no objection to Dr. Samuels testifying, but yet he objects to the PowerPoint, what he's saying is he objects to his testimony altogether. My guess is because it is actually helpful for Ms. Arias, and that's what the objection is coming from. All of these PowerPoint slides are something that is used to explain to the jury what Dr. Samuels is talking about. He is an expert. He has an expertise above and beyond what this jury, a typical jury, would understand because he is a doctor. So what these slides do assist the jury in understanding his expertise. Nothing is new. I can avouch to the court that this PowerPoint was completed this morning prior to coming to court. So that's why I'm more than happy to have him review them again, and he can take as much time as he wants. With regard to the actual opinions, Dr. Samuels is not changing his opinion at all. His opinion will be, and as it was in the report and during the interview when the state interviewed him, is that Ms. Arias suffers from PTSD. That is not changing. When he's talking about the picture of the brain and his objection to the picture of the brain, because he says that Dr. Samuels is a psychologist and therefore has no training in the brain, I think any psychologist out there would probably object, including his own Dr. DeMarte, because that's what psychology is the study of the brain. So to be able to claim that Dr. Samuels is somehow not an expert and unable to explain the different parts of the brain and how they work and how they affect actions or memories is ridiculous. The picture of the brain is talking specifically about the amygdala and the hippocampus and how memories are formed. During his interview and in the report, Dr. Samuels talks about Ms. Arias suffering from a dissociative state. In other words, she is complete denial about what happened. She's not dealing with her feelings. She doesn't have a memory of what happened. He talks about those memory gaps. The picture of the brain is there to assist the jury so that Dr. Samuels can explain to the jury why that might happen. And since the state on cross really went into the fact that Miss Arias seems to have some kind of a mental problem because she can't remember things, it's incumbent now upon the defense, especially for Dr. Samuels, to be able to point to the brain and say there are physiological reasons why people don't remember things in high-stress situations. And that's what Dr. Samuels needs the brain for, so that he can actually show the jury the parts of the brain that affect memory. And if the court wants to, he can come in and we can do testimony about why he's qualified to do that after 30 years in his doctorate. With regard to the Time magazine article, these are articles that he relies on in his research with regard to explaining memory and what the events and what sudden stressful events do to a person. The Time magazine article is just put in layman's terms so that the jury can better understand what happened. And what it is it's about a police officer who shoots somebody. And Dr. Samuels has a lot of experience in this type of work, actually, because he worked for the police department back in New Jersey, talking about PTSD that occurs with police officers when they have a shooting, even though that's what they're trained in, the possibility of it happening. The relevance of that is to discuss, mainly to discuss what happens physiologically to the body when there is a high-stress event. What happens to the amygdala, what happens to the hippocampus, what happens physiologically, that draining that we feel from the adrenaline rush, all of that. So it's used to help explain to the jury in terms that they can understand what happens under high-stress situations and why in those high-stress situations memories may not be formed, or implanted, I should say. With regard to the PTSD articles and intrusive memory slides, they discussed during their interview, obviously his report diagnosed her with PTSD. This is explaining what PTSD is. These are articles and research that are well relied upon in the scientific community, so he is allowed to discuss it. He is allowed to rely on those articles, being an expert under 702. So that is nothing that is disallowed. The slide is just so that he can help explain it to the jury. It's meant for an instructional explanation to the jury. And again, the jury's not going to get it. They're not going to have it back with them, so it's not like it's going to be confusing to them. It's just the opposite. And because he's an expert, it's not hearsay, because it's something that he relies upon in the scientific community. With regard to the slides regarding instrumental and expressive, that was also disclosed in his interview. He mentions, Dr. Samuels specifically talks about the fact that based on his training and experience, he believes that this was an unplanned crime, that this is not something that was pre-planned or premeditated. That has since been not allowed to be discussed. I'm not going to ask him that. But his reasoning for that, which, Mr. Martinez did not ask him during the interview, and we don't need to give him a roadmap of what he needs to ask. But based on his training and experience, the reason why he can say that is because there's research with regard to instrumental crimes and expressive crimes. Instrumental crimes are crimes that are premeditated. There is a goal to do something, and if somebody gets in the way of your goal, then a homicide occurs. Expressive crimes are typically more violent, and they are also more spur-of-the-moment type crimes. There's no thinking ahead of time. A lot of times, these types of crimes, there's been a lot of research which Dr. Samuels is relying upon in the scientific community to talk about these two different crimes and how they relate to crime scenes. So typically in premeditated crime scenes, you don't see as much of the violence, you don't see the melee, the craziness. In expressive crimes, you tend to see the craziness. That's ultimately how he gets to his opinion with regard to why he believes that this was not a premeditated crime. I'm not going to ask him that opinion. He knows not to go into it. But he can certainly talk about the different types of crimes in the research that goes into the types of crimes and the crime scenes and what the research tells us. It's not an opinion, it's just research that he's explaining. With regard to the one slide with regard to personality disorder, he's not changing his opinion. He's not going to say that Ms. Arias is suffering from some different personality disorder. It's just, it follows on the explanation of the expressive crimes versus instrumental crimes and how there's a link to different personality disorders associated with these expressive versus instrumental. So again, it's just explanatory, and it goes to the research that he relies upon in the scientific community, that's well accepted in the scientific community. The amnesia slides, dissociative amnesia, global, I think, amnesia. Those are all something the state has been made aware of through their interview and through the report. The state full well knows in this interview and in speaking with Dr. Samuels during his interview that Ms. Arias has no memory of what occurs and very vague memories of that after the shooting. That is something we've talked about for the past 18 days. So what those slides have to do with is the fact that that's actually consistent. Amnesia in somebody who experiences a high-stress situation like this can be expected, and it's not inconsistent to happen. So, again, it's research that Dr. Samuels relies upon, that it's well based in the scientific community that he relies upon to talk about amnesia and to talk about the dissociative state and to talk about Ms. Arias' actions afterwards and why she can't remember certain things. That's something that went into by the state on cross ad nauseum. And so certainly at this point, because it's already been noticed in his report, they talked about the dissociative state, it's something that this is being used to explain to the jury the science behind it, basically. And that's what a doctor does. That's what an expert does. They explain the science behind it. Other than that, Judge, I take issue with the fact that the state claims that this is a last minute, we're trying to hide something. He interviewed Dr. Samuels a long time ago. Nothing is new.
When did you interview Dr. Samuels, Mr. Martinez?
July 19th, 2011.
Ms. Wilmot, is it your position that Dr. Samuels has not changed opinion since that date?
That's correct. He has not.
Mr. Martinez.
Well, that's true that he hasn't changed his opinion. He still wants to bring in through the back door that this was a non-premeditated crime by now couching it in terms of instrumental and expressive. You've specifically precluded them from doing that. And so how is it that we are now going to allow him to testify about anything such as instrumental? In other words, he's going to, by what I hear, he's going to say, oh, based on my looking at this scene, based on my speaking to the defendant, I can now say that this was not an instrumental crime, wasn't pre-planned, it was unplanned, which goes to the ultimate issue of fact and invades the province of the jury. You've already ruled that that issue does not come in. So under any circumstances, whether or not there has or hasn't been disclosure, this issue involving the instrumental versus expressive crime issue should not be allowed. The other items, if she says that, for example, that this is something that I've known about, I certainly have known about the fact that she has this, or has claimed that she has amnesia. There's no reason why he can't say it. There's no reason why he can't explain it. Why do we need to read it? If they were going to do that, they could have just provided it to us so that I could go back, for example, and take a look at whatever article he's talking about. How am I going to be able to all of a sudden drop everything, go take a look at whatever this article says, so that I can then turn around and cross-examine him on that? That's the unfairness of that issue. And it may be that that is the opinion. But and with regard to the Time magazine article, I don't think that that's anything that experts routinely rely on, what is printed in Time magazine. But I have a grave concern regarding this instrumental versus reactive definition of what the crime is. Psychologists do not have the authority or the power under the law to tell a jury whether a crime is premeditated or not. That invades their province. And so under any circumstances, I do not believe that that's appropriate.
Ms. Wilmot.
I just want to clear something up. I'm not going to ask him if this was an instrumental crime or an expressive crime. I'm not going there. I'm not going to ask him anything of the sort. He's just explaining the research with regard to expressive and instrumental crimes. That is all. I'm not asking him the final opinion. I would know better than that. With regard to unfairness to the state because of the articles that he relies on, that's something that occurs every day in trial when any expert testifies. An expert can't lay out the millions of articles that they've read throughout the years that makes them an expert. If they did so, we would all be experts. That's the point of an expert. He has these articles that he relies upon.
And then, Judge, my motion in limine, which is still, the ruling is still in place, he can't talk about what a premeditated crime is. He can't talk what a non-premeditated crime is, or a crime of passion. That's something for the jury to decide. The fact that he's going to say, for example, certain crimes are not premeditated, and these are the characteristics, invades the province of the jury. He can't talk about that. He can talk about the defendant's state of mind. He can certainly talk about that all day long. But with regard to that ultimate issue of fact, that's for the jury to decide, not for him.
Judge, the minute entry, the motion in limine is regarding whether or not he can opine to premeditation. He can't, and I'm not asking him that. The questioning is not about, the research is not about premeditated crimes. This is the way they always go. It's just that there's research that links certain types of crime scenes to premeditation, certain types of crime scenes to expressive crimes. Is it always like that? No. And he's free to cross on that. But I'm not going to ask him the final question, and it's not invading the province of the jury when we're talking about the research that goes into crime scenes and state of minds.
All right. It is now 11:15. It appears that while the defense does not believe there is anything new, the state disagrees. So what I'm going to do is take a recess, allow the state to speak with your expert again. I'm going to have everyone back here at 1 o'clock. We will make a record at that time regarding the legal issues. This is obviously something that should have been raised in a motion in limine before trial if there was a problem. But that ship has sailed. So I'll see you back here at 1 o'clock. Mr. Martinez, you need to interview Dr. Samuels. We will let the jury know to be back here at 1:15. All right, anything else?
No.
We're at recess until 1:15.